All right, good evening, everyone. Thank you for joining us here this evening. Before we begin, I just want to thank all of you for joining us here, and I'm going to turn the program over in just a couple of minutes. I want to welcome everyone to Little Falls. Thank you for joining us. Tonight, we have an outstanding program for you that was actually brought to my attention by our freeholder director here in Passaic County, John Bartlett, and he proposed the idea of something that he's done in several other towns in the past, but he thought Little Falls was a great place to host this event this evening. And it's preparing for the future, guardianship and estate planning for parents of special needs children and adults. And this is something that, unfortunately, there's a lot of need for information in this area with little avenues to get that information. And tonight we're hoping that any questions that you may have may be answered. And I want to thank our freeholder director, John Bartlett, for bringing this presentation here to Little Falls. And I'd like to turn the microphone over to him.
Thank you very much, Mayor Damiano, for your hospitality. Thank you to Tyler here at the Little Falls Civic Center for all of his help getting us set up. I know we've got a couple of folks from Little Falls government. Councilwoman Maria Cordenaro is here with us, as well as Councilman Anthony Segoba. Thank you all very much for being here. I also want to welcome at the back of the room Paul Aronson, who has the longest title in state government. Paul is is Governor Murphy's ombudsman for individuals with intellectual or developmental disabilities and their families. So I know that I've met with Paul about the services that Passaic County provides and could provide for families affected by all kinds of developmental disabilities, including autism spectrum disorders. And he's working hard to look out for those with the most need. And I appreciate, Paul, you're taking time to join us here tonight. I am, in addition to being your freeholder director and your neighbor up the street in Wayne, I'm the son of a pediatrician. And I grew up watching my father work with families with all kinds of kids, with all kinds of needs, developmental, physical, and what have you. And I saw the role that an effective advocate can play, someone who understands the systems that you're operating in. I see Councilman Munir Almeida from Halden is here with us, as well as being a teacher, so you know about schools and some of the challenges you can face. And I went on from that experience to become an attorney, and although I don't practice in this area of law, the areas of the law I do practice, I recognize the ways in which just understanding the process, just understanding what's involved, can be so important, and having someone who will provide that information in plain language can really be transformative for families. I hope in some of the ways that I watched my father help families as I was growing up. So since I've been on the Passaic County Board of Chosen Freeholders, we have recognized each April as Autism Awareness Month, in part by providing some sort of public program like this one. And the topics vary and the locations vary. But this is a program we've offered before, and I'm glad to offer it again, because when we provided it in Wayne a couple of years ago, it really seemed to be very impactful for those who were there with us. You know, in great part because, as those of you with children on the spectrum or children with other disabilities know, there's one set of considerations and opportunities and resources up to age 21 when you're under the jurisdiction of the educational system. And after that, very often right at the moment in a parent's life when things can become a little bit more challenging and questions of what happens next start coming up. It's a moment when you have a lot of new things to figure out. And there are a lot of legal questions, a lot of questions about how the system works. So that's what we're here to learn about tonight. I hope this is helpful and informative. I did mention I'm a lawyer. In fact, all three of us up here are lawyers, and I feel compelled to give the little disclaimer that you'll see on law firm websites and some other places. We are lawyers, but this is not legal advice, and nothing we say here creates an attorney-client relationship between you and anybody up here. By all means, think of us all as resources to call upon, but today's program is informational only. That goes for what's said, that's going for what's shown to you, but we hope that that information is useful and helpful. And we're very, very privileged to have with us a panel of two exceptionally knowledgeable and experienced women in this field. To my immediate left is Naomi Becker-Collier, who's a partner at the law firm Pashman Stein Walder Hayden, whose practice for 18 years, as long as I've been practicing, has focused on the sets of needs that families like yours can have. And we're very, very fortunate to have her here with us again to talk about this. And to her left is our Passaic County surrogate judge, Bernice Toledo. The surrogate judge, which I'll let her explain a little bit more, has jurisdiction over the set of issues that are particularly relevant for us here today. Things like guardianship, things like estates. And because of that, her expertise and knowing her office and how it works is an important part of what I hope you'll get out of today. So I'm going to sit down and be quiet, and I'm going to let our exceptional panel here talk to you a little bit about what the issues are, and then we're going to have ample time at the end for Q&A. In the meantime, don't ever hesitate to hop up, grab yourself some coffee. Thank you to the Fine Grind here in Little Falls for donating coffee, and the Councilwoman Coordinator for donating cookies. So with that, our esteemed panel, Bernice, let me bring the microphone over to you.
Thank you. Good evening, everyone. Let me stand up because it looks like you can't see me back there. So my name is Bernice Toledo. I'm your surrogate court judge. Can you hear me okay? Okay. I'm your surrogate court judge, and the surrogate's court is here to serve you in a variety of capacities. As you heard the freeholder director, John Bartlett, say that we handle a unique set of circumstances that are relevant to you today. So you know the term surrogate. The surrogate means one who does for another, right? We've heard of surrogate moms who have babies for those who cannot, right? So I empower people to make legal decisions for those who cannot. So the matters that are attended to in my court are matters of the deceased, right? So a person who has passed away had a legal voice. The voice is gone, but what's not gone are their assets, their belongings, their children, their developmentally disabled child, their checking account. It's all there, except when you go to transact, when you go to do things, you can't say, well, you know, that was my mom. I can just step in her shoes and do things. Motor vehicle won't listen to you. You have to be empowered to do that, and that happens in my court. Another set of people who can't for themselves are children. So 2 things I do for children is I receive funds that they inherit or receive as part of a civil award, and I safeguard those funds. I safeguard $25 million that belongs to different children throughout the. I see eyebrows going up. I don't get to use it. I don't get to borrow it. I just safeguard it. I can't use it for the weekend and return it on Monday morning. That's illegal. But I safeguard it, try and do the best I can, to get a return within the parameters of the law. And then when the children turn 18, when their legal voice has ripened, then they can, I issue a check, they get their money, and they can use it for whatever they want, education, car, whatever they wish. Another thing that I do is I receive filings for adoptions for all children in Passaic County. So all adoptions filed in the county of Passaic are filed through me. Again, you have children whose voice has not yet ripened, so we're going to get them somebody who can be their voice, and that would be an adoptive parent, and that's filed through me. And lastly is for filings of incapacitations. Incapacitations are what's known as guardianships. And you've heard the term was on the flyer, and it's going to be a lot of what we're going to talk about today, or at least one of the steps we're going to talk about today for planning for your special needs child. Or even, and it's not just for a special needs person, it's any person who becomes of age who no longer has the capacity. So that could be a child who's had Down syndrome all along, and then once they reach the age 18, they need somebody to make decisions for them because now they're adults. Or it could be somebody who had capacity, think of grandma with Alzheimer's, and their voice starts to dwindle. The loudness of their voice is going down, their capacity is not as clear as it was, and the future does not look like it's going to restore anytime soon. So in those instances, we would file a guardianship. So in this instance, are we dealing with, most of you are parents of developmentally disabled or cognitively limited children, correct? And I say children, but they're either close to turning 18 or they already are. And one of the things I see a lot is a child is about to turn 18, and I get a lot of frantic parents come into the courthouse and say, I don't know what to do. He's going to turn 18. Now what? I haven't filed for guardianship. I'm not prepared. There's no emergency to filing it. The thing with guardianships and why it's becoming more relevant now is because of things like HIPAA, right? So we know HIPAA offers privacy to people for their medical records to be disclosed, for their records to pass from one doctor to another, but without more than necessary eyes look at it. We know about that, right? But that becomes a hindrance when you have, let's say, an 18-year-old son who's developmentally disabled, and now you need to consult with their doctor. Now you need to call Horizon Blue Cross and Blue Shield to settle a claim, and nobody will speak to you because guess what? You don't have guardianship. And you're saying, but this is my son. I bet just last week, I was handling his stuff. Well, sure, last week he wasn't 18. Once he turns 18, magically or not, he's an adult, and he has to have somebody to stand in his shoes. Can it wait? It depends on your situation. You should always start thinking about it. You should prepare about it. You should seek counsel, an attorney for help. Is it super urgent? It could be depending on the circumstance. If your child is going to remain in your home, if you don't need outside placement like a residential placement, maybe it can wait, but it's something that you do ultimately have to start thinking about. Think about for a variety of reasons, including the fact that you have to plan for your children's future. When you pass away, you have to have tools in place. You're the guardian, you have to have tools in place for somebody to succeed you in serving. You have to have services in place to make sure that your child isn't left out on the street, or that the agencies are aware of the services that might be needed when that time comes. Are there alternatives? Well, sure. I mean, depending on your child and the functioning of your child, maybe you don't need a guardianship. Maybe your child is what's referred to as high functioning. So they can't exactly live in the world without some sort of a safety net because unscrupulous people might take advantage of them, but that they have a good deal of capacity, that they can give consent, that they understand what they're doing, then maybe you could go for a power of attorney. But again, these are all issues that you need to consult with an attorney to figure out what works best for you, for your family, and for your child whose needs are changing as they go to the threshold of adulthood. So with that little preface, I will yield the floor to Ms. Naomi Collier so that we can hear her expertise.
So as John mentioned, we've actually done this presentation before together. I've been practicing for 18 years. This is all I do. I help families plan for the God forbids, death, disability. And through that practice, I help a lot of families that have dependents with special needs, and how is that incorporated into their estate planning. So in the past, we've done this in a pretty laid-back manner, try to give you some information that you might find helpful. Surrogate Toledo gives a very interesting perspective because she sees it on the other end when the matter goes to court. So I'll be speaking about the legal concepts, and Surrogate Toledo will chime in as it relates to her role in the court, which is an interesting perspective, and we're lucky to have that here today. So everybody has materials in their packets, but it will be up there as well. But if it's a little hard to read, I just wanted to point that out. We're going to touch on the highlights. If you have questions, we encourage you to ask them. There's a lot of you here, so if it gets to be a little too much, then we might just finish the presentation and invite you to speak to us afterwards, but let's see how that goes for now. So I mentioned a lot of what I do is estate planning. Not all of my clients have individuals in their families with special needs, but a lot of them do. So we are going to talk about common mistakes when you are planning for your estates when you have a dependent with special needs. We're going to start with estate planning basics because frankly that's important to understand for the whole conversation. What is a trust? It's a foreign concept to many people, so we're going to talk about that and how does that fit into estate planning when you have dependents with special needs. Additional planning considerations you might want to be thinking about when you have a dependent with special needs. And then we're going to wrap it up with what Surrogate Toledo was speaking about with guardianship and how you can help your dependent with special needs, what the options are in that regard. Okay. So how many of you have children that have UGMA accounts that were established for them at one point in time? So bank accounts that you're the custodian over or a family member is the custodian over. So those are particularly problematic when you have a child with special needs, because once they turn 18, they might be qualified for government benefits, but if they have too many resources in their name, that can be problematic. So it's important to, I have a lot of people that come to me about 6 months before their child's about to turn 18, but the truth is this is a conversation that would be helpful to have sooner than that, so you can address those issues that might disqualify them for benefits once they turn 18. Probably the biggest mistake is not planning at all, because if you don't plan, then chances are likely you are not going to achieve your goals. So what I mean by that is there are a lot of people that don't have wills, for instance. Maybe their estates will go pursuant to the intestacy law, which means that the law indicates how the assets are going to be divided. If you are survived by only your children, it will be divided equally in most circumstances by your children. If you have a child with special needs that's receiving benefits, then they're going to have all of this money in their name. They're going to be disqualified for benefits. So it's really important, and we'll talk about different ways you can plan to protect those benefits. So I have people that come to me that did the planning, and they never changed anything else. So they've got a great trust in place that's going to protect their child's benefits, except all of the money is passing outside of the trust. So while it's important to put the planning in place, it's equally as important to follow that planning, and we will talk more about that. And along the same lines, we have life insurance, we might have a 401k, we have assets that pass to beneficiaries named on those assets. So if they're passing outside of the special trust that you've created to protect the benefits, again, we're going to have an issue and they're going to lose those benefits because it's an available resource once it passes outside of the trust. And that goes to I have a lot of clients, special needs kids and non-special needs kids, that will come to me, and part of the process is to review what the assets are, how they're titled, how the beneficiaries are listed, and very frequently, I've got people that name their ex-wife on the beneficiary designations. It's important to review them. There are things in the law that will help under circumstances like that, but, you want to make sure that everything is coordinated. Okay, so these are the estate planning basics. Once you turn age 18, legally, nobody can make decisions for you any longer. So frankly, anyone over the age of 18 should consider putting several documents in place. Depending on your circumstances, maybe they don't have to be as complicated, but once you turn 18, if you become incapacitated and cannot make financial decisions on your own, if you have not appointed somebody under a power of attorney, then nobody has the authority to help you with anything. I get a lot, but my husband will help me or my children will help me. Nobody has the authority once you've turned the age of 18. Same for healthcare decisions. So God forbid you become incapacitated, you cannot make decisions for yourself, you can't speak for yourself. Nobody has the authority to make medical decisions for you unless you give it to them. This goes to what Surrogate Toledo was talking about earlier. If you don't have these documents in place and you become incapacitated, then chances are likely somebody in your family is going to have to petition the court to be appointed your guardian. That's how they would get the authority to make these decisions for you. In practicality, is it always a problem? It's not always a problem, but it's a problem when it becomes a problem, and then it's too late. So, these are pretty simple documents. They can be pretty inexpensive to put in place and a lot cheaper than a guardianship. So once you turn 18, these should be considered. I also talk to my clients with children that are going on to college. If their kid is in college and there's a medical problem, no authority to speak to the parents. So it's important for them too, okay? So those are the documents that matter during your lifetime, the power of attorney and the healthcare documents. Once you die, those documents die with you. There is, the will controls your assets that you own at the time of your death. If you don't have a will, then your assets owned individually by you without a beneficiary designation will pass pursuant to intestacy law, as we discussed earlier. But that document doesn't matter until you pass away.
Can I explain on intestacy a
Sure.
second? So, as I was explaining, as you heard, if you have a will, things will go, your assets will go to whomever or however you designated in your document. The will is the guiding instrument. That's how you see in movies, you leave $1 million to the parrot, right? So you can love your parrot so much you're laughing. Well, it's because parrots live a very long time. But if you pass away without a will, there is no such thing. It goes by the laws of intestacy. So your beloved parrot will be left out. I mean, is that significant to anybody here? No, it's not. But where it is significant is if you have no will, who is going to be the person to stand in your shoes, right? And what happens is usually the person who passes away, let's say they have 4 children, child number 1 will say, well, I want to be in charge. And they execute the paperwork. They now have to get permission from everybody else who's equally, let's call them equally ranked, equally entitled to serve, right, as an administrator. So child number 1 makes the application. Child number 2 says, yeah, sure, it's fine, number 1, I'll you can do it. Child number 3 also renounces and says, yeah, I'm okay with it. And child number 4, what do you think child number 4 does? Child number 4 objects. Child number 4 always objects. Which means they have to come to a hearing. The hearing is before me. I can appoint somebody. I can appoint either one of the competing applicants. I can appoint a third-party attorney, which can be costly. And if they're dissatisfied with my decision, then that's appealed and it starts brand new. I'm on the county level at the state superior court level. So sure, things go by the law of intestacy, but it's not that easy. There will be hurdles in between, including that you have to get bonded. And by bonded is, like you go to a bail bondsman when somebody's in jail. It's the same thing. You have to get an insurance policy, a surety bond saying, I'm going to do the right thing. And if I fail to do the right thing, then this bond, this insurance policy is going to cover those people, those beneficiaries who should have inherited X and they didn't. It's not free money though. I mean, 2 big burly men will, just like on TV, will come and find you and figure out why you didn't act within your fiduciary capacity and why you breached it, and they'll get their money one way or another. But passing without a will, it's not a problem, as Ms. Collier said, until it's a problem. So when child number 4 objects, when somebody objects, then it becomes an all-out battle, and that's why you need to have that document particularly in place.
And let's not forget, if you don't have a will, maybe you don't want your assets to pass pursuant to the laws of the state of New Jersey. Most people want to choose where their money is going. So the only way to ensure that that's done is to create a will to effectuate your goals.
And when you have a special needs child, if they're receiving Medicaid, if they're receiving some sort of housing subsidy, remember, most times the limit of assets that they can have in their name is $2,000. So what happens is when they inherit, according to the laws of intestacy, because the will did not allow for them, because there's no trust, so now it has to go by the laws of intestacy. So that means those 4 children that were due to inherit, those 4 children are going to get equal shares. If it brings that one child, the developmentally disabled child, over $2,000, you've now done them the disservice of having them possibly be disqualified from their services, possibly losing their place in line when they were on a waiting list for a particular program. So it's important to think about that and have a will, because you want to insulate any assets that they may receive so that they are not counted against them for purposes of Medicaid and program qualification.
Assuming they're properly structured, which we'll talk about.
Assuming they, well, yes, then that's
right.
That's
which
fair.
we'll talk about. Also, when you have a child that's under the age of 18, the will is the document where you appoint guardians to act in the event that their natural parents are no longer alive. For a child that you've gained guardianship over the age of 18, while not legally necessarily not enforceable in the same way, when I have parents of special needs children, I will include language in my wills as to who you think the appropriate guardian would be when you were no longer around. And perhaps you can talk about how that impacts the application to the court for the guardianship.
Well, when there's, are we referring to testamentary?
Yeah.
Okay.
So we've got a kid over the age of 18. The parents or the guardians, they're no longer alive.
Okay. So if the guardianship did not provide for a successor, and you have a will, you have what's referred to as a testamentary guardianship. Basically, you're naming the person who you think is best able to take care of your child. It's not binding on the court. But it does speak to who you thought was the best and most able person. So let's say you picked, Aunt Millie twice removed, and that doesn't make sense on its face because, she's a little bit of a distant family member. But then you figure out, well, okay, the reason that's guiding to the court, because now you figure out that the closer family members, maybe there's an immediate aunt, maybe there's an adult sibling. It turns out when you scratch beneath the surface that they had issues, they had financial trouble, they have legal trouble, they have substance troubles. So in you making that, let's call it a recommendation in your will, then the court is guided by that when subsequent guardianship applications are made. Again, it's not binding on the court though, because you may make your will today and not pass away for 5 years from now. And what happens? Maybe Aunt Millie, twice removed, who was the perfect person, is now suffering from dementia, right? So they will always look at the applications. The court will always look at the application at the time it was received, irrespective of what's in the will. Again, it's guiding, but it does speak to the court, and it weighs heavily, but it's not binding. The decision, and you should be glad, because life changes, circumstances change, health conditions change, and you want the court to make the best decision for your child.
So thank you. So I want to talk about generally what a trust is. A trust is really just an agreement between the person setting up the trust and that's the grantor, and the person that is in charge of making sure that the trust is followed. That is the trustee. There are different ways to create trust documents. You can create a trust during your lifetime. That's called an inter vivos trust. You can create a trust under your will. That's called a testamentary trust. The trust essentially lays the ground rules. It says what distributions can be made for, who the beneficiaries are, if there's money left over when that beneficiary passes away, where does the money go. So you're setting up an agreement directing the trustee to make certain decisions. The trustee is a fiduciary, which means they have to follow the terms of the trust, or else they can be personally liable. They can be sued for breach of fiduciary responsibility. But this goes to special supplemental needs trusts, because that is a very special kind of, there's all sorts of trusts, but a supplemental needs trust is a special kind of trust that allows you to put away money for a loved one with a special needs that might otherwise be receiving government benefits, Medicaid, SSI, that has a resource limit, that $2,000 that Surrogate Toledo referred to. So the purpose of the supplemental needs trust is to essentially supplement the basic needs that are being taken care of by those governmental benefits. So it's a little counterintuitive. It's not supposed to pay for your basic food, clothing, and shelter, but literally could send the trust beneficiary on a trip around the world. But it is structured that way because if a trust is allowed to make distributions for basic food, clothing, and shelter, then that person is not going to be eligible for needs-based benefits because they have too much money available to take care of those basic needs for food, clothing, and shelter. Okay? There are two distinctions that are important to understand when it comes to supplemental needs trust. A first-party supplemental needs trust is a trust created with the beneficiary's money. So perhaps there was a lawsuit and there was a large lump sum settlement and the beneficiary's money is directed to go into that supplemental needs trust by the court. It allows the beneficiary to continue to receive those needs-based benefits, but it has certain requirements, the biggest one of which is that it has a payback provision requirement. So let's say over the lifetime of the beneficiary, they received $100,000 in funding from some sort of needs-based benefit and they pass away. Well, that first $100,000, the state has the claim because they have to be paid back for the money they've put out before the money can be distributed to the beneficiaries. Does that make sense? Good. A third-party supplemental needs trust is I'm taking my money and putting it in a trust for somebody else's benefit. So it was never their money, no payback requirement. Those are the biggest distinctions. So you want to be very careful that the trust is properly set up because that is that can be a huge problem when they are applying for or trying to qualify for benefits. And also, you never want to commingle. Like you don't want to put you don't want to put the beneficiary's money into a third-party special needs trust because you're tainting the trust. So that's a very important distinction to understand. Okay. A supplemental needs trust, like I said, they can be set up two ways. During either you can create it during your lifetime or you can create it under your will. The difference is that trust isn't under your will, isn't actually a trust until you die, because your will is not effective until you die. When a person creates a trust under their will, when the will is probated in Surrogate Toledo's court, they also apply for what are called letters of trusteeship. So it's at that point that the trust is established. The big difference, and we'll talk a little bit about why you might want one over the other. Very frequently when we have dependents with special needs, family members would like to help benefit that person. If you have a trust created under the will, it is harder for a grandmother, an aunt, or an uncle to direct assets into a trust created under a will, because what happens if the grandmother dies first and this will has not been probated yet because the testator of the will is still alive? If you create an inter vivos trust, even if it's not funded during your lifetime, it's just kind of like a bucket sitting there waiting to receive funds, then if there are multiple family members that would like to benefit that child, they can direct any bequest to them under a will or a beneficiary designation on an asset into that trust. So I'd say 99% of the supplemental needs trusts that I've done over the last 18 years have been inter vivos trusts for that reason, because frequently there are many different people that would like to benefit the child.
Now, with that, communication is key. Now, as she said about the trust, it's like this bucket waiting to receive. But you have to communicate this to your family members, because well-meaning grandmas can, surprise, leave money for your child because they feel like, well, little Johnny's developmentally disabled and he'll need something or somebody to take care of him, so let me leave this $10,000 for him. You must let the immediate family members who would be likely to do that know not to separate funds, not to leave funds that would otherwise go to the child's name. There are also other possibilities that if a trust is not immediately within your planning, there are also other ways to insulate money for your child. One of those things is a recent-ish development, which is an ABLE account. ABLE account means it's a bank account. It's called an Achieving a Better Life Experience. You can put up to, is it $14,000 a year?
$15,000. It's tied to the annual exclusion amount.
Okay. Up to $15,000 a year for a maximum amount of $100,000, so that money is not counted against your child for purposes of losing their funding. But again, you have to let immediate family members know so that money is not somehow or another left to your child. A life insurance policy, something that does not leave it to them directly, because that would compromise their benefits.
The ABLE account, it is an important planning tool. It is particularly important when you have a child that has their own assets that they can put into an ABLE account, because just like the first party supplemental needs trust, it has to have a payback provision to the state. So it is better than nothing, but in most circumstances, when you're trying to leave assets to somebody that was not their assets, it's better to put it in a trust for that reason. Also, there's a maximum you can give per year. That $15,000 isn't, aunt and uncle both want to put in $15,000. They're capped at $15,000 total. So it's not like multiple people can put in $15,000 per year. It's a total of $15,000, which can be limiting depending on what your planning is. Okay. And we talked before, we can set up the best estate planning documents in the world, but if the trustee doesn't understand what the rules are and how it can negatively impact benefits, it can create a problem from a benefits perspective. So it's important to name a trustee that is going to follow the rules of the trust and understand the impact of not following the rules and what that might be. Okay? Because if they're on benefits already, every year there's generally a redetermination to make sure you're still eligible for those benefits. And if it's determined that the trustee's been making distributions that were contrary to the intent of the trust that would negatively impact the benefits, then that beneficiary might owe back some of the benefits that they were receiving based on that trust being in place. So that's an important consideration. So we just touched upon the ABLE accounts. It is essentially a state-run savings program. New Jersey now has a program, but much like 529s, you can kind of shop for the state that you want to have the account in. You have to be a U.S. citizen or a legal resident, and you have to have been determined developmentally disabled before the age of 26 for that tool to work. Distributions from the ABLE account can only be for qualified disability benefits, and there's a list of those if you look on the state's website, but it's specific, and it hasn't really been around long enough for me to know how strictly that's going to be policed. But I think we have to assume that they're going to be looking to see what the distributions are made for. We talked about the limitations on contribution, and honestly the biggest issue is that payback requirement, especially if it's not the individual's assets. Because if they weren't their assets and it didn't pass through their hands, it's better to be able to direct where they go if they're not all used by the beneficiary during their lifetime.
And when Ms. Colley is talking about distribution, she's talking about what's the money going to be used for, right? So if you're on some sort of social service program, SSI, Medicaid, housing program, then that's your basic necessity, right? So you can't use your ABLE account or your trust account for food or for a roof, because if you're paying for your own food and you're paying for your own roof, then what do you need government benefits for, right? So the idea is it's for other needs that would enhance the life, that would improve the extras. So if your child responds well to, I don't know, pet therapy, it would be for pet therapy, for a special therapeutic camp, for a particular type of caretaker, things that would not otherwise be covered by not TANF, the general assistance grants, Medicaid, anything that has basic government eligibility requirements.
Correct. Okay. So this just kind of piggybacks on what we were discussing with putting those documents in place, and how do you figure out what your child is going to need when you're no longer here to take care of them. So what I recommend to my clients is to really think about what their life is going to look like when you're no longer here taking care of them. What are their needs going to be? Will they need some sort of group home? Is there somebody that might step into your shoes to take over the role that you have been contributing to their life all of this time? So in order to understand how much money they might need, that will help you create a budget in terms of what kind of expenses they'll need when you're not the one there taking care of them. Life insurance is a tool that is frequently used to cover that care. You can buy a life insurance policy that names the supplemental needs trust as the beneficiary. Certainly, depending on what the assets look like, that might be a more tax favorable way to fund that care. We talked about how important it is to properly structure those inheritances into a proper type of trust so that it does not negatively impact their government benefits that they're receiving or might otherwise be entitled to receive. And maybe they didn't need the government benefits while you were providing 24/7 care, but maybe after you're gone it will become more important. So definitely something to think about. And while not legally binding, I think just a very practical consideration, it's a difficult time of transition when you who have taken care of this person for his or her entire life, nobody's going to ever be able to fill your shoes. But the more information you can give the person that might be stepping into your shoes, the more helpful it will be to that person and also to the person you've been taking care of. So a letter of intent could talk about anything in terms of what you envision, the care to look like. What do you do for holidays? What is their favorite birthday cake? Sharing those pieces of information that only you might have. Again, not legally binding, but I think that it is an important tool for whoever might be stepping into your shoes. Okay. So let's talk a little bit more about guardianship proceedings. So it's a protective arrangement that is established by the court, as Surrogate Toledo stated earlier, for those people that require assistance to care for themselves. If they are incapacitated such that they can't take care of their finances or their personal, that is when, generally speaking, the court is petitioned to have a guardian appointed. You file in the county where the person lives. So if you live in Passaic County, you'd be filing in Surrogate Toledo's court. It is a motion to the court where you're essentially outlining why this person needs a guardian, indicating why you are the person that should be appointed as their guardian. With those pleadings, depending on the circumstances, generally there's 2 doctor certifications that are accompanying those pleadings to the court, essentially backing up what you're saying in terms of that person's incapacity and inability to care for themselves and manage their affairs. In the case of guardianships under development, if the beneficiary of that individual is under the Division of Developmental Disabilities umbrella, it looks a little bit different. You might be able to submit an IEP that was issued, I want to say, in the last 2 years.
Correct, in the last 2 years.
Yeah, along with 1 doctor certification, so you only have to get 1 doctor certification. The doctor certification in a general guardianship, not under DDD, the doctor must have seen the person you're trying to have declared incapacitated within 30 days. Under the DDD umbrella, the time frame is extended a little because that 30 days can be hard to coordinate, to 6 months, correct?
Correct, and even after the report is issued, they're only good for a certain period of time, for about 6 months. So some folks have come to me, and at the minute their child turns 17, they want to file a complaint with the court. First of all, it's not ripe. They're not old enough. They have to be 18. And second, any doctor's certification that you have is going to be stale, right? Your doctor's certification has a diagnosis. The child was diagnosed with, universal developmental delay, and a prognosis. It's not going to get better in the foreseeable future. However, you need those things updated because circumstances change. People regain capacity. They restore capacity. So they can't be too old. Your certifications can't be too old. Again, the IEPs can be older, can be up to 2 years, but doctor certifications have to be relatively recent. And even after filing, the matter has to be heard relatively quickly and resolved.
If you're appointed as a guardian, there are, it's not particularly onerous, but you do have filing requirements every year, financial filing requirement and a filing of well-being. You learn about that when you're petitioning the court, and there's videos to watch and books to read. So, and the circuit courts are very helpful. They give you forms, and generally speaking, when I file guardianships after the judgment of incapacity has been issued, and the letters of guardianship have been issued by the court, most of my clients handle all of that going forward on their own. So they are very user-friendly.
So a letter of guardianship basically says, yes, Mom, I agree, your son cannot do for themselves, and I'm going to appoint you to be the guardian of this child, of the incapacitated. But that will not be the end of your interaction with my court. You'll come in, and as soon as that happens, and you receive your judgment of incapacitation, you come into my court to qualify as a guardian. You come in as a guardian, and even that won't be the end. It's an ongoing relationship because, remember, the court sees it as being an extra set of eyes to watch out for the welfare and well-being of your child. So once a year, you'll have to touch base back with the court with an annual reporting indicating that the condition still persists, that the child has not, and I say child, but now adult, has not regained capacity, and if there are any assets accounting for where you were then when the judgment was entered to where you are now. And every year you'll have to continue that until either the child restores capacity or your child passes away.
So there are different types of guardianship. There's remember earlier we talked about the power of attorney. You can appoint somebody to help you with finances during your lifetime. Or the healthcare proxy, you can appoint somebody to help you with their healthcare decisions. Same kind of split. There's the guardian of the person that helps with personal and medical decisions. Guardian of the property helps with financial decisions. Frequently they're the same person, but they don't have to be, depending on the circumstances. I find more so in my older adult guardianship matters that might be split for one reason or another. Perhaps one child is better at managing the finances, the other child is the one that's naturally been taking care of the medical decisions. But it can be the same person, it can be different people. You can also have co-guardians appointed, which frequently happens, particularly with special needs children. The parents that have been taking care of them all along go in for co-guardianship. That way, if one of them passes away or becomes incapacitated themselves, there is a second guardian that can act. Can you speak to whether or not the court will allow you to appoint successor guardians?
So first as to co-guardians, let's address that. Now, as to co-guardians, we see it a lot where you have a parent and the parent is getting up in years and they have the incapacitated person's oldest sibling or sibling, an adult sibling, to be in charge, because that way there's a safety net in place. If I pass away, well, then my 29-year-old daughter will take care of my developmentally disabled son. That's how you see that. You can appoint, co-guardians to maybe even more, but whoever it is seeking to serve, you should have a good relationship with them, because you're going to be making all decisions together. Now, you're not serving in the alternative, you're serving as co-guardians, which means you're making decisions together, which means it could be cumbersome when you have to meet for one thing or another, to meet for the doctor, to meet for a surgical consult, or something like that. Now, as far as successor, at the time that you establish your guardianship, it's kind of like what we were discussing before. You're going to say, well, I'm making my application to be the guardian of little Johnny. If I were to pass away, the successor guardian is, my sister, little Johnny's aunt. But again, it's not binding on the court, because we don't know where little Johnny's aunt will be, emotionally, financially, legally. But it's highly suggestive. The court does accept the recommendation, into consideration, but the court can take another direction if it sees fit.
And whoever might be seeking that successor guardianship would have to petition the court.
Correct.
Just
yes.
like the
You have
initial
to appear-
guardians did.
You have to appear all over again. The court has to see you. You have to pass the test. They have to make sure that you're there. They have to, in layman's terms, they have to eyeball you and make sure that you have the willingness and ability to take care of somebody of that level of needs, irrespective of what level it is. But for that particular child, that applicant can make that level of care.
And whenever you file a guardianship, you have to notify all interested people. So let's say you appoint the great aunt, and in your will, and you say, I think that great aunt Mary would be the best successor guardian when I'm no longer around. Well, any heir at law, the siblings of that person would have to be notified, so they have an opportunity to say, yeah, she's not the right person for the job. Here's why we're better for the job. So it's really the court's way of making sure that the absolute right people are in place to help that person that lacks the capacity to take care of themselves. Okay. Oh, guardians can be general, which means essentially that person cannot make any decisions for themselves because they have a level of incapacity that restricts them from doing so. The court has the authority to make a guardianship limited. So perhaps your child can make it's determined that your child can make medical decisions for themselves but are not good with finances. Then that can be a limited guardianship for finances. And also the court can, if they're determined by the doctor and upon recommendation from the doctors and perhaps the court-appointed attorney that is appointed by the court to represent your dependent with special needs, maybe they might make a recommendation in terms of what rights that the alleged incapacitated person can retain. Then the court has the authority to carve that out in the final guardianship judgment. Do you see that a lot?
Do you see
Where they're making, where they're limiting what the guardianship?
It tends to be an all or nothing. It tends to be. Actually, the exception would be, for X, Y, Z, but not for this. And incidentally, unless a judgment of incapacitation addresses the issue of voting, an incapacitated retains the right to vote unless the court order speaks to it. People automatically assume, well, he was adjudicated incapacitated, he can't vote. That's not necessarily the case. But again, so back to whether they're limited, most of the time it's an all or nothing. Most of the time. The exception is, the exception would be, well, we want it for this, but not that. But, that's the reason why we also have guardianship of the person, right, versus guardianship of the property. That tends to be the split.
Yeah.
But specifics, not so often, no.
Okay. So I get asked this question a lot when families have dependents with special needs. Do I absolutely need a guardianship? And the answer to that question is not necessarily, it's very fact specific. I have done voluntary estate planning documents for clients that are turned 18. They're still in the school district, want their parents to continue to be able to help them. They understand what the power of attorney does and what the healthcare proxy does. And under those circumstances, we use voluntary estate planning because it's the least restrictive means to achieve the goal of letting the parents continue to help them once they've reached the age of 18. The downside of that is they can revoke that document. So if they decide that they no longer want you to help them, then they can revoke it just as easily as they put it in place. There's also an alternative in the courts, which we don't see, I hardly ever see, called conservatorships, where essentially the individual's capacity is such that they really do need some help, but they're not totally incapacitated. The conservatorship allows them by agreement to agree to the court appointing a conservator to work with them, to help them with financial matters.
If we have to if we have to compare it to a particular document, I would say conservatorship is like a power of attorney, except a power of attorney can be made without having to appear in court. You have your signatures, it's witnessed, it's notarized, and that's your document. You're not going before a judge. A conservatorship, would you agree, is the equivalent of, it's kind of like a power of attorney.
It's like a power of attorney with court oversight.
Except the court has been involved and says, okay, because remember, again, that person is agreeing to be overseen. They have to have some level of capacity. Because if they don't have the cognitive capacity to agree, then are they really agreeing, right? Do they really understand what's happening? So it's similar to a power of attorney. Right. But again, you're involving the courts. It can be more expensive. So why would somebody do it? A lot of times you see that when there are feuding family members, and you see that a lot when siblings are fighting over a parent's care. Parent will agree to, okay, well, this is the way we're going to do it, so that they can preserve peace at the Thanksgiving dinner. Now they have a court order saying this is the arrangement we're going to have.
And I've seen it when there is the potential evidence of financial abuse.
Mm-hmm, correct. Mm-hmm.
So sometimes banks will identify improper or potentially improper transactions and say, like, we're not giving any of this money out until we have some sort of document from the court which brings it into the court. And if they're not totally incapacitated, then that's where the conservatorship frequently comes up, though I don't see it a lot. So, okay. So unless Surrogate Toledo has anything to add, that is the end of my presentation.
Now, as to powers of attorney, again, they can be an option to guardianships. Remember, guardianships can be expensive. So what are different ways that we can address them? You can go on the New Jersey Court's judiciary website, and there are forms for people who are self-represented. I don't recommend it. I do recommend that you look at them, that you print them, because it gives you insight as to what the court will need. You've heard this presentation from Ms. Collier, and she's telling you need 2 doctor certifications, but in some instances you can substitute with an IAP. Are you going to remember all this? Probably not. When you have the forms in front of you, it makes you familiar with what you need. Some people use it so that they can execute the process themselves. They're essentially serving as their own attorney. It's a highly complicated process. You have to give notice to all people who might be an interested party. You have to provide those proofs to the court. You have to be timely in your submission of your doctor's certifications. So you can wind up falling into minefields. Even though you thought you were doing everything right, then by the time you finish this or correcting that, now your medical records have become stale, and you have to start again there. And it can be troublesome. If you're filing a guardianship, I recommend you consult an attorney. If you cannot afford an attorney, look at the pro se forms on the website. There's an organization called SCARC, Sussex County, but they also tend to people from Passaic County, Association of Retired Citizens, SCARC, SCARC, who does it for you. It's not free. It'll still run you probably, I'm guessing, but it's going to run you, $1,500 or something plus court fees. So count on paying some money to get the guardianship filed. There's the Bureau of Guardianship Services. They can file for you, but they are very, very inundated. So it can take easily a year or 2 to get a guardianship filed. So if you're in the middle of a pressing matter, that might not be the best option for you. You should, just as a matter of course, start planning with your DDD agency, the Division of Developmental Disabilities. Make sure that you start your post-21 planning. After they turn 21, they're no longer within the jurisdiction of the school. So you want to make sure that you start, in that instance, you want to make sure that you start looking into programs and asking all your questions early, really early, a couple of years early, before 21. Because some waiting lists for programs are years long, because things are changing all the time, because you want to explore all your opportunities for residential placement if that's what you need. You want to know that, familiarize yourself with the law. Congregate care, that means like a group home, is not really what we're supposed to be doing, right? The law, the administrative code is against congregate care, where a person can live in a family setting or independent, but like with supports. That's the direction they're supposed to be in, and if that's available to your child, that's what you want for your child, the best case scenario. So coordinate with your DDD, have good contact with your school counselors. You'll have a special needs counselors. They go by different titles in the different schools. Make sure you have a lot of contact with them. Your children will need their individualized education plan, which is the IEP, but they also need a habilitative plan, which is going to figure out which direction they're going to with regard to work planning, with regard to housing situations, with regard to employment. They should also, what's the name of the program? Make sure that when your children receive money, that they are again within the $2,000, and if not, that the money is insulated. Let's see. Social Security has some work incentive programs. You can contact 866 WINS for New Jersey. WINS is the work incentive program for your children. You contact them, figure out what it is that they're eligible to work for. Through those programs, you can find out if you can get an income waiver. So any income they received is waived as far as eligibility requirements, so long as you filled out the proper paperwork. Am I giving too much information at once? No? You'll be glad to know that Passaic County is actively working together with the freeholders on a special needs council, so that we can unify all of our special needs services, so that we can work collaboratively with DVRS, the Division of Rehabilitative and Vocational Services, so that your children have services all in one place. That should be up in place in the next year or so. I get a thumbs up. They're actively working on it, and at that point, you won't have to wait for the seminar. You can reach out to the county and get information as to what you need for your child as you need it with the resources we have.
A frequent question I get on guardianships is when am I supposed to file? And I know we touched upon this a little bit earlier, but I generally tell my clients, if they've come to me before their child turns 18, that we should be prepared to submit the documents for filing about 30 days out of their 18th birthday if we're able. Depending on the county, we get on the calendar a little bit quicker. Every county is different. But I'd say generally 30 days gives the court an appropriate amount of time to file those documents and schedule it for a hearing and appoint an attorney for the alleged incapacitated person. Once that attorney is appointed, they meet with the alleged incapacitated person, they meet with the family, the proposed guardians, and they're not officially the eyes and ears of the court. They represent that person, but they submit a report to the court of their findings. So that's I'd say 30 days out. Do you think that's reasonable?
Fair. Mm-hmm. Yes, very much. And one last thing, with respect to powers of attorney, if you're going to have one for yourself, or if your child has sufficient capacity to sign a power of attorney, your power of attorney should, and tell me if you agree with me, should be a durable power of attorney.
100%.
A durable power, she said 100% for those of you who didn't hear. A durable power of attorney will withstand even after you yourself or whomever it covers loses their ability, their capacity. So you see on soap operas, somebody gets amnesia. You see in real life, people get strokes. So we want it to remain in effect even if you're not there to oversee. So you think to yourself, well, why would you have a power of attorney if it's not durable? A lot of times people will give you a power of attorney, let's say a parent gives you the power of attorney, but, to run their errands, to deal with the mortgage company, to go to the bank, but they know that they're getting those monthly bank statements, or they're checking online, so they can oversee what's going on, and they can, and they can direct it, right? But if your power of attorney is not durable, right, if you're not saying, not only do I trust that person when I'm overseeing from my home computer, when I'm looking at the bank statements, I also trust them even if I weren't able to supervise them. That's the durable part. So if you have a durable power of attorney, or if your child has sufficient capacity to sign one, then it should be, keep that language in mind. It should be a durable power of attorney. Again, best done with the consultation, in consultation with an attorney who can guide you on things like that, which are pitfalls that a layperson may not understand, and that person downloading a power of attorney from the internet may not understand.
And for those of you with existing powers of attorney, go look at the power of attorney, make sure it has that magic language that says that the power of attorney remains good even if I become disabled, because that's what makes it durable. Also, healthcare documents and powers of attorney, make sure it has a HIPAA release language in it, because technically I can give you the authority to act for me, but the doctors aren't supposed to give me any information because I haven't authorized you to receive that information. Some doctors' offices might have it on file, but we put them in the powers of attorney in the healthcare documents.
Well, first of all, join me in thanking our panelists for I know you got a lot of names and acronyms thrown at you today. I'm going to throw a few more at you because I do want you to let you know you've met our county surrogate. Our Passaic County Department of Senior Citizens, Disability, and Veterans is a resource point for some of the care and other issues that you may need to access. We have some 7-day pillbox giveaways at the back table that I think have our senior department's phone number and website. If not, any of our departments you can find by visiting us online at PassaiCCountyNJ.org. That includes our Preakness Healthcare Center located in Wayne, all the programs I just talked about through our senior offices, as well as the surrogate's office and elsewhere. We are recording this to post on our Passaic County YouTube channel, so it'll be up in a few weeks if you want to re-watch it. I'm going to quickly redo the legal disclaimer from earlier for a couple reasons, one of which I want to remind everyone on the internet that anything we're talking about here is New Jersey law, and the law of your state may differ if you're watching this somewhere else in America. And then, of course, none of this is actually legal advice, merely informational. But with that in mind, I'm sure a lot of you are left with a lot of questions. I'm going to moderate a quick Q&A, and I'm actually going to take the privilege of my place at the podium and ask the first question, which is, I think from speaking to folks in this situation, very often there's a concern after they're no longer there to look after the well-being of their adult child, that their adult child may fall into some sort of situation involving abuse, or as I think you mentioned, Naomi, the idea of a guardian or someone else acting on their behalf, but not in their best interest, either by way of stealing money or in some other way. What are the protections that can be put in place, either through the surrogate's court or through well-written legal documents, to try and mitigate that kind of risk?
Would you like to take that?
Well, through the surrogate's court, once you're granted guardianship, one of the automatic protections is that you're going to check in with us in the form of an annual report once a year, and it will discuss how the incapacitated person is doing, if their prognosis remains the same, and if there are any assets. We want an accounting of those assets. So that's one particular protection that is in place with respect to the courts.
In trust documents, you can include language. Perhaps you might want a care manager to oversee your loved one's care, and you could include language in that document that would direct the trustee to have them evaluated periodically by a care manager and allow for the distributions. I actually use care managers a lot in my practice. It's kind of, the feet on the ground for elderly people and younger people with disabilities. You want family members, if they're in a group setting, to be a constant presence. So to the extent that you can impart that wish on siblings, I know a lot of parents don't necessarily want to put the siblings in charge, but if, through example, they can understand how important it is to check periodically and at different times, so not when they're expecting you to come visit. That's important also in, in an elderly setting as well. So that's frequent advice that I would give.
That's great, thank you. I want to open it to questions. I just ask, since you guys are at the microphone, repeat the question when it's asked so everybody has a chance to hear. Yeah, I see one way at the back.
I have a two-part question about guardianship. What, if you go through a lawyer, what would you expect that to cost? And if you put yourself as the parent, as guardian of a child, and the only sibling lives out of state, what is the chance that the court would grant that in your death, the other child to be the guardian living out of state?
So I think I'll take the first part of the question, which is always the question, what is it going to cost? And my very lawyerly answer is it depends on the circumstances. I can tell you that I charge hourly for my time. I try to be reasonable with my time. I have associates that I work with that I oversee, so if it can be done at a lower hourly rate, then we handle it that way. Surrogate Toledo's suggestion that you familiarize yourself with those forms is a good one, even if you're going to use an attorney, because frankly, the more organized you are by the time you get to me, the easier my job is, the less time I have to spend. You also have to be mindful of the fact that the court, I said earlier, will appoint an attorney to act on behalf of your the person you're trying to get guardianship over. There is an option to ask the court to appoint an attorney pro bono, which means the office of the I can't remember. It's the public defender. Thank you. We've used that in some circumstances to save expense, but it does take a lot longer to get that guardianship through because the Office of the Public Defender is very backlogged. So when we get what's called a return date, when the papers are filed, generally speaking, under a regular guardianship, we usually get in about 30 to 45 days. You think that's fair?
Correct. Yes.
And 4 months. So I was going to say 4 months at a minimum because we recently filed one where they wanted pro bono representation for their child, and then when they saw the return date, we had to go back and say, no, thank you, we will pay somebody to do the job of the court-appointed attorney. So that's something you have to be mindful of. The filing fees are about $200. And again, it really depends. If I chase after doctors because they're not putting what they need to put into the certification, it costs more money if I'm the one chasing them. And inevitably, the doctors don't put in what they're supposed to put into the certification because they do have to be detailed. You can't just make a medical determination because the court is really looking to make sure, does this person need to have somebody appointed to act for them, and does it rise to the level where their rights should be taken away? So and they become more strict on that, I'd say, in the last few years.
Now, with respect to filing fees, as you said, the $200, that goes to the court. That has nothing to do with her fee. It's a court fee. If there's a particular hardship with that, you can't just pick up the phone and say, I can't afford to pay it, but you submit some paperwork, indicate that there's a hardship in paying that fee, and the court will consider whether or not to waive the fee or part of the fee. That's just as to fees. That's not the legal cost. That's a whole other story. And it's not just the legal costs. Even if you go pro bono, pro se, even if you represent yourself with your own forms, there's the filing fee involved. So that's your $200. You'll probably have to pay, your doctor certifications, and that'll run you some money. You may need a psychological evaluation. There are certain expenses that you're not going to be able to get around, except what you're doing is adding to your frustration. So if you're organized, you'll save yourself a few dollars if you can get the assistance of, there's SCARC, there's also LAMP. LAMP is Legal Assistance for Medical Patients, LAMP. It's out of St. Joseph's Hospital. And again, it's very limited. If your child is in for something unrelated, a broken leg, and they need legal assistance through certain hospitals, I know St.